Yes. Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean, to the respondent in this matter. Please grant him. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyama case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Tushapatia mingi mkonazi mpaka tumechoka, sio? What does the court say something to do with compelling reason? And this is the Court of Appeal decision in the Nyamaza versus Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to his phones. What they did not tell you is that he gave them the passwords and they're keeping quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the story. Let's finish that one. It's a simple thing, a 1-minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit, and what he has said here on oath, is that, in fact, I've given you a password. Take a password. It's not about the password. Give the court. Just confirm. It's not about the password. They're telling you.
Yes, Your Honor. The issue is not about the SIM or the password. It requires a lot of things.
No. Your part is special. I'm running the show.
Okay.
Now, they're telling you about witnesses. They are not telling you in the affidavit which witnesses, but they're telling you something else that is imaginary, that they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the Gigiri police station, headquarters CID, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the litigation. Then have they convinced you, Your Honor? And I am saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say pre-bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why we have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPO. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I am certain that they ignored it because Mr. Whitty, my friend here, would have told them. And I don't know why he's not telling them, but Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant this fundamental right. Article 20, sub-article. Might start by wanting to grant to ensure that this person enjoys the fundamental right. But they still give me this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear articles. So that the court, once it has noted this kind of, can I call it, bad faith application, will be able to see. Let me qualify it to say, why does it come under bad faith? You have an IO who has come to court today. What does the IO do? Refuses to answer questions. Just he will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves. Why should you believe him today? That once you release this person to him, he shall be treated well. Why? You cannot believe him because he denies publicly even his own boss. I know now how Jesus felt when Peter just... And then, Your Honor, if that is the position, and then they come and tell you, oh, this, the public order and issues like that, and that the safety of this person depends on them keeping him in custody. Where does that come from? Because Article 29 is clear. This gentleman must enjoy his fundamental rights. The security, it is provided by the state. It is guaranteed. Guaranteed. So they can't come here by a mere application and tell you that he cannot be safe. And they don't quote that article in their application. Why? They avoid it intentionally because it is black and white and it is clear. So bad faith again from the investigating officer. And he is my friend. Now, Your Honor, I know when the state wants to respond, they will start telling you about probabilities. They want to tell you that nowadays it's on probabilities whether a person will appear or not, that they anticipate. And you can see from their affidavit, they are alleging, they are saying likely to abscond, likely to interfere. It remains likely. Let us change that scenario of likely. Let us move from the bail bond issues first of all. Let us go to what the law says today. Law is very clear. And there are three authorities that I will give the court. One I've already given, the one of Oyamo. Then there is one of Richard David Alden versus the Republic, that is the number 40-something. Oh, you see, I'm even so confusing myself here. Richard Alden versus the Republic, that is in the High Court case number 48 of 2016. And then the other one is Dwight Sagarai versus the Republic. That is number 61 of 2012 before the High Court. Proudly, let me say that I appeared in the matters. What did the court say when somebody makes an allegation to do with somebody is going to interfere? The court did not say probably. The court said must put evidence, must show something, must produce something. Why? Because if we were to leave it to imagination, the sky would be the limit. So if you are saying somebody is interfering with witnesses, you must show that he directly interfered or indirectly or has attempted. In the affidavit that have been given, nothing is there. They are saying likely. That was held by Justice Corrier in the Dwight Sagarai case and was also supported by Justice Lasit as she then was in the Richard David Alden case. If you're going to say somebody is going to abscond, what does the judge say in Lasit? She says that you must be able to show that an attempt has been made by the person to try and abscond. Not only that, maybe there's a ticket, plans of traveling, or arrangements made. So I'll ask you, Your Honor, and I will give you the answer. Have they given you that? Then the answer is no. Such that even in the case of Oyamo, when they are saying that public order and public interest and all that, the court in Oyamo was the Republic, and this is a court of appeal case, and that is the law. What does it say? For you to say that there is public order and rest and all those things that they are saying, they must show. All this unrest that has been going on has not been because of the OCS. Tuesday, tomorrow, there will be an mandamano in reference to somebody else. Not him.
You know, we hope that goes on record. That matter of fact, we hope goes on record.
Your Honor, it's even on social media, and let me tell you why they can't tell me not to say anything about social media. In his affidavit, he said they got these issues from social media.
You know,
Don't shut me up.
If that counsel can go to social media, we just ask him the contact. As he says it from social media, please record it for us. We will use it.
Yes, Your Honor. And if that is the position that they are going to say and they are going to use it, let me tell you, Your Honor, it was not in relation to the OCS. It must be mentioned that it is the OCS and it must be accurate. Let us not generalize. That is why that law has never been overturned. Until today, it has never been overturned. So, what then does that leave the prosecution with? An empty shell, Your Honor. Today, they have come to this court, not, as I said, to do this case in a proper manner, but in bad faith, which have demonstrated, and an affidavit that does not meet the requirements of Article 49, and at least what they will come out from with here is that at least I've given them a definition of compelling reasons. Yes.